Hi guys, welcome back to my channel. This is Bat Up with Ola. My name is Lua, and I'm so thrilled to be here once again. Thank you so much for all your comments on the last video and on all subsequent videos. I'm going to display a few comments now, and I'm really grateful that you decided to give me feedback. Feedback is very important to me, as I've always said on this channel. It's very important for me to know if you're gaining something from the videos that I'm putting out, and if there's something that you'd like to come up on the channel, maybe a guest or a topic you'd like us to talk about, or some areas that you'd like us to clarify, please do not hesitate to always put them in the comment section, and of course send them to houseoflivingstones@gmail.com. That's my email address. Once I see the email, I will do my best to reply as soon as possible. Please, people that are asking me for my contact, my phone number, please let's not do that. Okay, let's just communicate by email. I promise that it's more effective than any other means of communication that you might think of. If you'd like to connect with me on other social media channels, you can see the handles, my handles, in the description box. Please connect with me on those, and let's not talk about phone numbers again, please. Thank you so much. Also, I'd like to say that I'd really love to make some money from this channel, so I'm imploring you to please watch the videos till the end and share them as far and wide as possible, so that other people can come watch and gain value, and in exchange I can also make some money. I haven't made a dime from YouTube since I started almost 2 years ago, and it would be really lovely to make some money, because YouTube counts the hours of watch. Okay, that's watch hours, and right now I have I'm over 1,000 watch hours away from even being monetized or making a dime. So if you would please watch the videos till the end and share them with people who would also find value in them, maybe the watch hours could increase, maybe I could get monetized before the channel is too, who knows. And it would be really lovely to make some money so that I can buy equipment and I can film videos, more videos, because sometimes I'm pressed for time, and the time that I have a chance to film videos, it's dark or it's noisy where I am and what have you. So maybe if I could make some money off this, I could invest it in getting gear and equipment, to facilitate making more videos, despite the odds of time, of sunlight, of natural lighting rather, and noise. So thank you so much. Today we want to talk about a very important topic. I'm saying that it's a very important topic because it is now a part of my life. Okay, I started this line of work last year, and I've been a year and over 4 months on the job right now, and it's been a very interesting ride, and that's why I want to talk about it. I want to do it in about 6 videos, okay, because it's a whole discipline on its own. Okay, whether you're a lawyer or a layman, you can practice this discipline. You can get involved, and even if you're a law student, it might help you, weigh your options and decide if you want to go in this direction. But whichever you are, lawyer, law student, layman, it will help you, I promise. It will give you some sense of direction. Whether you're a lawyer, a law student, or a layman, this will help you. I implore you to watch this video and the 5 other videos that I'm going to be doing on this topic. Make sure you watch them. The topic that we want to start talking about today and in subsequent videos is mediation. Mediation. If you're familiar with ADR, that's alternative dispute resolution, you will know about mediation. But even if you're not, we're going to talk all about it, and you will find out all you need to know about it in this video and in subsequent videos. So I've recently become a mediator. It's been about 16 months over that, that I've been on the job. I work at a government-owned mediation center, and it's been a very interesting ride, and that's why I want to talk about it. I will be spicing up the conversation with some examples of mediations that I've sat upon, and I hope that you find it interesting, educating, entertaining, and informative, as well. Thank you so much. Stay tuned, and let's talk about mediation. Mediation is a non-binding, voluntary, and private dispute resolution method or technique whereby parties try to make their way towards a negotiated settlement or agreement facilitated by a neutral third party called the mediator. So let me explain it this way. There are several means of alternative dispute resolution. When we talk about alternative dispute resolution, we're talking about alternatives to going to court, to litigation, okay? Because we all know all the problems that are bedeviling our court system in Nigeria and worldwide. We're talking about the time, the cost of litigation. We're talking about, the animosity that litigation breeds. So many things. We're talking about technicalities that sometimes impede justice and so many other things. So people have decided to adopt other means of settling disputes, and this means some of them have been with us for ages. Some of them are things that we used to do traditionally before, but now it's been modernized, and we have about 5 to 10 of those techniques. Some of them are negotiation, arbitration, conciliation, arbitration, mediation, mediation, arbitration. That's a fusion of the two. We have the ombudsman, the executive tribunal. We have adjudication. We have the neutral fact finding, and of course we have the mediation. But the most popular ones, especially in Nigeria, are negotiation, arbitration, conciliation, and mediation. So we want to talk about one of them, which is mediation. So this is how mediation goes. There's party A and party B who are in a dispute. So the two of them have not been able to come to a settlement. But instead of going to court over that dispute, they decide to submit to a third party, a neutral third party who is called the mediator, who will then sit upon their case, listen to both sides, and help them reach a settlement. Now, the important thing to note in mediation is that the mediator does not give judgment. He or she does not make the decisions. Rather, he helps parties come to a point where they ask each other, what do I want? What do you want? Can I do what you want? Can you do what I want? Can you move a bit? Can I move a bit? Can we reach a compromise? Come to a middle ground? Can we meet each other in the middle or at the middle? And if they are able to do that, they reduce their agreement into writing and it becomes binding. So you will note that there are some keywords in the definition that I gave. One is that mediation is voluntary. Voluntary in the sense that parties are the ones that will decide that we want to submit to the jurisdiction of a mediation center or a mediator. Okay, you can't force them. Parties are the ones that will submit to the jurisdiction voluntarily. Okay, you know that in litigation, for instance, when you file a suit, the other party is notified and they are compelled to come to court to answer the case against them. That's different. For mediation, if you go to mediation as party A and party B is called or summoned as the respondent, because you are the complainant, as the respondent, and they say, no, I don't want to do mediation, nobody can compel or force them. So that's what we mean by voluntary. Both parties have to be reasonable and they have to decide voluntarily that we want to settle this matter by mediation. So that's what voluntary. Then I said non-binding. Non-binding in the sense that the process is non-binding, but the decision is binding after they have reached an agreement and both parties have signed and agreed that this is what we're going to do. It is binding and enforceable. We'll talk about enforceability much later. But non-binding in the sense that at any point in time, a party can decide this is not working for me, I'm leaving. I no longer want to continue with this, even though I voluntarily submitted myself, but we've not reached an agreement, a conclusion, and I no longer want to continue. So it's non-binding in the sense that they can say, I'm not doing it again, I'm going. You know that you can't do that in litigation. So that's another thing. Then you heard me mention private. Private in the sense that mediation sessions are private. You know the court is public. Anybody can walk into the court and sit down and listen to your matter, even if you are divulging, dirty secrets. You cannot be protected except in the cases of maybe a little child where the rules of court permits that the judge can hear the matter in chambers and some other specified situations. Most court cases are public. Anybody can stroll into the courtroom, listen to what you're saying, hear your secrets, even publicize it, within the bounds of what is permitted by law, of course. But what I'm saying is that for mediation, nobody even has to know that you have gone to a mediation center or that you have appointed a mediator or that you are going through the process of mediation. So it's private. It's just between you and the other party and the mediator. And then I mentioned negotiation. Negotiation is an entire form of ADR on its own, but it comes into play in mediation in the sense that both parties will negotiate their way into an agreement. So party A can say that for this damage that you cost me, party B, I want 50,000 naira. Party B can say that, okay, I'm going to give you 10,000. And then party A says that I'll come down to 40. Then they say that I'll meet you at 20. Then the mediator will try to encourage them. Let's do what's reasonable. Think about the laws. Think about the recovery process. Think about this and that. And then party B says, okay, 35. Party A says, okay, 35. So there's been a bargaining, a negotiation. That's what I mean by a negotiated agreement. And when I say agreement, we're talking about the compromise, okay? That both parties have decided that we agree to do this. So mediation is all about the parties. It's party-centric. That's the most unique aspect of it when compared to other forms of ADR or even litigation. It's party-centric. We are trying to look at what is best for both parties, what is doable, what is fair, and what can both agree to do. And both parties will make their own decisions. The mediator does not make decisions, does not hand out judgments for any party. He or she can only facilitate the process. Both parties will make their own decision. So that is what mediation is all about. Let's try to explain this technique of ADR by talking about the WH questions. I love the WH questions so much, because I'm sure that if you watch other videos that I've made, you will notice that I always try to explain things using the WH questions. They are very important. They are the easy way out. They help you understand things and appraise things properly. So we've talked about what mediation is. That is mediation. Now let's talk about the who. Who can do mediation? Anybody can do mediation. Any party that is willing and reasonable to submit themselves to mediation can go ahead with it. Okay, I've done mediations on tenancy matters, tenancy disputes, landlord-tenant disputes, labor and employment matters, contracts, commercial contracts, breach of contract, torts, civil torts. I've done mediations on matrimonial causes, child welfare, child custody. Done mediations on simple contracts. Okay, I'll give you this, you give me this. It didn't work out, somebody defaulted. I've done mediations on loan defaults and debt recovery, what have you, all sorts. I've also done mediations on inheritance and land disputes, property disputes in general, all sorts of disputes. So practically any type of dispute can be subjected to mediation if the parties are willing. That's the most important lesson that I've learned in the over 16 months that I've been a mediator. And when I say I am a mediator, it doesn't mean that I'm no longer a litigator or a litigation lawyer. I still go to court, I still do court cases, criminal matters and what have you, but I also do mediation now. So that's why I want to talk about that aspect, because the aspect that I've talked about the most on this channel has been litigation, civil litigation, criminal litigation, but today we're talking about mediation, and in subsequent videos we're going to talk about mediation as well. So that is what mediation is, and those are the types of matters that can come to mediation. Once it's not a criminal matter, okay, you cannot mediate a criminal matter, although in some instances you can actually mediate on some aspects of a criminal matter. For instance, a fraud matter. If the defrauding party has agreed that they actually defrauded you and they want you to mediate on how they are going to pay back or how you are going to recover the monies that they've defrauded you of, you can actually submit that to mediation. Yes, I've seen it done. So mediation can cover any type of matter, okay, but stricto sensus, criminal matters are not subject to mediation. The court has to adjudicate upon that and make a decision, because we have a law, we have the criminal code, and we have all other laws that regulate criminal matters. So criminal matters cannot come to mediation. Okay, so that's the who. Now when should mediation occur? Mediation can occur before you go to court. So oftentimes when I'm making my introductory statement, which I'm going to talk about later, to parties, I always tell them that the government has set this place up so that we can, settle matters amicably before they become subject to litigation or before it turns to public fighting. So mediation can occur when a dispute has happened. Mediation can automatically occur, but before you go to court. That's one. Two, mediation can be court compelled. We have had instances when people are already in court and the court told them, go to the mediation center, go and mediate on this and come back for report of settlement. So mediation can also occur when a matter is already in court, if it is court compelled, or if parties decide that, okay, we don't want to go ahead with the litigation, we are withdrawing the suit or the matter, and then we want to go to the mediation center or want to go to a mediator to mediate it for us. So mediation can occur before or after you go to court, but it's essential that the mediator or the mediation center does not, and because they cannot even, usurp the jurisdiction of the court. So we often have that challenge when parties come to our center and they do not disclose fully to us that the matter is already in court, and then we invite the other party, and then the lawyer writes us that this matter is already in court and you cannot usurp the jurisdiction of the court. Hey, please, we are not trying to usurp the jurisdiction of the court. We had no knowledge of the full facts of the matter. And honestly, in mediation, the Bible says that the first to state his case is always right until his accuser comes. That Bible passage is going to be very important for you if you're going to be a mediator. Please put it in your right or left hand or in your heart and keep it. So sometimes we don't know the full facts. So that's why, but we need to hear from one party so that we can invite the other party, and then we start afresh with them. But sometimes what we see is that the other party writes through a lawyer that I'm not coming, we're already in court, where's this person here, you can't usurp the jurisdiction of the court. So a mediator and the mediation center cannot, in actual fact, usurp the jurisdiction of the court or other lawful bodies if they have already been seized, or if they are already seized of the matter. But if not, it can be mediated upon. And even when they are seized of the matter, they can decide that you guys go to mediation and then come back for a report of settlement. Or if mediation breaks down, come back and let's continue from where we stopped. So that can happen. So that's the when of mediation. Now let's talk about the why of mediation. This will take us into a whole topic on its own, which we are going to discuss much later, but I'm just briefly going to talk about it. Because mediation is party-centric, okay? Parties get to make their own decisions. So you get to decide what is favorable to you, but also favorable to the other party, okay? Because mediation is win-win. Both parties have to win in some way. You can't have it all, okay? In mediation, you can't have it all, and you're not going to lose it all as well. Mediation is win-win, not win-lose or lose-win or lose-lose. It's win-win. So, and also because mediation saves time, it's private, like I said. You can even check, the whys from, the definition that I gave at the beginning of the video, because, it's voluntary, it's non-binding. You can decide that you're not doing it again in the midst of the mediation. It's private, it's time saving, it's resources saving, okay? And you get to make your own decisions. So many reasons which we are going to talk about much later, but that's the why of mediation. And also because it helps to free up the court docket. It's good, to reduce litigation, helps to preserve good relations between parties, and so on and so forth. We'll talk about that much later. Then, how is mediation done? In my next video, we're going to be talking about how mediation is done. Then I will tell you about my life as a mediator so far. It's been almost 18 months, almost a year and a half, and so I want to talk about what I've experienced so far, how I've conducted my mediations. I've been a mediator and co-mediator in several instances, so we'll talk about that in the next video. Make sure you keep watching and tell a friend to tell a friend to tell a friend to subscribe to Battle with Ola and enjoy this mediation series alongside others. Toodles.